The first item today is consideration of a continued petition, and that's in consideration as PE1458 by Peter Cherby on a register of interest for members of the Scotland Judiciary. As previously agreed, we are taking evidence today from the Judicial Complaints Reviewer, and members have a note by the clerk and a submission from the petitioner, and they've sent a link to the previous Judicial Complaints Reviewer's annual report. And can I welcome Gillian Thompson OBE, the Judicial Complaints Reviewer, to the meeting. I now invite Ms Thompson to make a short opening statement, no more than 5 minutes, and after which we will move to questions. So over to you, Gillian.
Good morning, and thank you for inviting me. I'm just going to say a very few words just to put today in context as far as I'm concerned. I've been in post since September 2014. I have a background in public service, was a civil servant for 36 years, and since then I've gathered to myself a group of board memberships on charities, third sectors, and now the Judicial Complaints Reviewer. Just by way of where I'm at the moment in terms of the work, since that was something that you asked my predecessor, since I took up post, I've had 22 requests for review to date. So as of today, I have 17 outstanding from that 22. I'm actively looking at 3 this week, so hopefully we'll get rid of those by Friday. I did inherit a backlog of 14 from my predecessor. I cleared those around the 25th of March 2015, so it just gives you a bit of a feel for how the work is going generally. The waiting time, if you like, for people is around 4 to 5 months, but I haven't had any complaints about that, although I appreciate that it's not ideal. I wrote to the committee at their request on the 12th of January. I'm supportive of a register of interests, always have been, and that remains my position today. Okay. Okay.
Thank you, Gillian. In a letter to the committee you wrote, we live in an age which transparency about interests and activities of those in the public eye is regarded as good practice. There is a perception that anything less is the result to attempt to hide things. This would seem to suggest that anything less than a degree of openness associated with a register of interest would not constitute best practice and would be perceived as an attempt to hide things. Would this be a fair interpretation?
Absolutely, yes. Yes, that remains my view.
Okay. David?
Thank you, Convener, and good morning. In your opening statement there, you said you were in favour of a register of interests. Can you expand that in a wee bit? Why you're in favour of it?
Well, for the reasons that I set out in my letter in January, I think that people who are in public service, I might go further and say particularly, people who are paid, if you like, by the public pound. I don't see that there is a reasonable argument to be made against providing information, within reason, about other activities. People in this room, including myself, keep a register of interests. It's not particularly onerous in my experience. Of course, we would be talking potentially about there being a register somewhere and someone would have to keep it and all those points I made in my letter. However, if one thinks about it on a reasonably regular basis, they need to be updated. I will be updating my register shortly because of taking on some new and some different responsibilities. So, but it is simply, for me, it's about a mindset. I can't see arguments against. I have to confess, I find that rather difficult. So if you would like me to give a balanced view, I'm not sure on this occasion, although I'm experienced in giving a balanced view, I'm not sure on this occasion that I can do that. I think that in particular, in the environment about which we're talking about in the context of this petition, people want to be able to feel that they are getting an even-handed response at court, if you like. Whoever is sitting there in judgment, there's no bias, there's all of those things. And I think a register would go part way, I mean, it's all part and parcel of a wider picture, to reassure people that nobody's hiding anything.
Thank you.
Jackson.
Good morning.
Hello.
Do you consider yourself part of the establishment?
Well, I suppose that depends on where you're sitting, really.
I ask.
No, probably not. No,
oh, right,
no, I don't.
Well, I don't know if I'm relieved or not. It's just that, as far as I can see, the establishment, insofar as it exists, has been unanimously against any such, as has the government, no doubt, in the personage of Mr McCaskill, who was the government at the time that we received the advice, but he will speak for himself in due course. Our difficulty throughout all of this is obviously your predecessor was quite sympathetic, and from what we've read, that you have been too. The former Lord President, whose principal argument it seemed to me to be that unlike members of this Parliament who have the opportunity to answer back, members of the judiciary would not have that opportunity if challenged in some way. Ironically, however, he deigned not to come before the committee to answer back in person to any of his assertions on these matters, so we've always had to sort of try and read the runes, or I think privately our former convener and deputy convener were able to meet him, but they're no longer here. His argument was that, I think essentially, that there was no need in this era of transparency for light to shine on the judiciary, but that potentially some great malfeasance of justice would occur if it were so to do, but primarily that they had this obstacle to being able to redress any assertions that were made based on the register as it would exist and any claims that might be made of it. Does that resonate with you as sufficient grounds to disbar such a suggestion?
No. My understanding of what he had said before was that, as far as he was concerned, Lord Gill was concerned, judges took an oath to uphold, certain values and so on and so forth, and therefore, anything further than that wasn't required, because the public was able then to rely upon people in that position knowing what they needed to do and doing it, as it were. Now, my understanding is that since the Judicial Complaints Reviewer post was put in place in 2011, there is now a recusal process. Judges can recuse themselves. There is a register or a list, at least, as I understand it, of those people who have done. But I'm not persuaded by that argument, no. Well, people at the moment are able to make a complaint about the conduct of a judge in whatever form. And I would have thought that potentially some way of challenging or answering back or having a review taken of, there is a list and whoever is making the complaint. I don't know. I mean, I can see that there might be a need to extend the complaints process, perhaps. I don't know, but it is a normal part of public service. People keep a register. It's not. It's just common sense for me, anyway. It's common sense.
Okay, thank you.
Kenny?
I see the logic and where you come from. Can I just ask, though, who would you see as imposing a sanction in the event of a breach or failure? Would that be back to the Lord President, or would it be to yourself? Who would be the final arbiter of a failure to register or a failure to properly register?
Well, it's a bit of crystal ball gazing, isn't it? I mean, as the Judicial Complaints Reviewer role stands, it does what it says on the tin in terms of the regulations. All I can do at this current juncture is to examine whether or not the rules have been followed in terms of the complaint. I don't look any further beyond that at all. I think that there would need to be consideration, obviously, as to how the process would work, but the Lord President currently has responsibility for sanctioning judges in the event that something is found against them in terms of their conduct under the rules, and I would have thought that that would sit, you know, squarely on the shoulders of whoever comes along as the Lord President in future.
And presumably the register would be financial and pecuniary, because a lot of the recusals that are made at the moment will be on the knowledge of a witness or a relationship to
Yes. Well, I mean, it's a register of interest, isn't it? I gave you my little register of interests, including what I'm paid and, you know, who I support by way of charities, and including my membership of the Scottish Dachshund Club, just really to underscore that, you know, it's yes. So the answer to that is yes. Whatever is deemed appropriate for others, such as yourself, and, you know, government ministers and so on and so forth, why should it not be deemed appropriate for people who are sitting in judgment of others?
John Molson.
Thank you, Convener. Good morning, Ms Thompson.
Morning.
At the present moment, we have seen the establishment of a voluntary register of recusal, and we just want to try and get that issue over, that at the present moment, for a judge or a sheriff to recuse themselves, it's done voluntarily. And could you confirm that is the case?
As far as I'm aware, that's the case, yes.
Yeah, it's just that in terms of the public register, we've just seen the establishment of a new private bank, the first private bank that's been established for 150 years, claims to have 250 shareholders. Now, it's been reported in some of the press that some of these shareholders are judges and sheriffs. Would you think it would be appropriate for those judges or sheriffs to actually register if they were shareholders in a private bank?
Well, why would they not?
You know, I'm just saying.
Yeah. I'm just raising it as a question. It's not something I've thought about in terms of coming here, but I'm looking at it from a point of view that if there is anything at all that could be construed by a person in the street using everyday common sense, that something could get in the way or might be perceived to get in the way, then I think that should go on a register. But we need to remember that's not for me to make those kind of decisions, even should we ever come to that position.
Yep. The reason why my understanding you've been invited along today, Ms Thompson, is to give us your views, because we respect the role of Judicial Complaints Reviewer, and we took evidence from your predecessor in pursuance of this petition. And it is to try and hopefully indicate to the committee where we can take this petition and the kind of issues that are being raised. And you did say that the ordinary person, or to paraphrase you, the ordinary person in the street should get to know whether or not a judge or a sheriff has interests that may impact upon their serving or hearing a case in front of them. How far, in your view, would you want to see that be taken? Because there's issues about financial interests, there's issues about people appearing in front of them who may be members of the same golf club or same society as them. You've made reference to your Dutch Hound Society membership. So how far would you want to see that register going in relation, if there was a register established, in terms of sheriffs and judges' register of interest?
Well, I think that, as I'm on record already of saying, you know, at the outset I said that I'm supportive of my predecessor's position, I think that there should be a register. Judges should have a register, and on it they should note their interests. Okay, now, would we ever get to a position where in a court somebody would say, oh, well, I just want to register, this is the judge speaking, I want to register the fact that I know this person, or I'm in the same golf club, or I don't know this, you know, I don't know. I mean, in the context of us having this conversation today, I don't know. It would be necessary to have a bit more thought about the practicalities of all that. All I can say is that from my own point of view, when I go to a meeting, we have a point at the beginning of the meeting where we are asked, for example, whether there's been any change to the register of interest that we keep in a particular context. But I think, you know, it's not for what I'm saying, perhaps just to clarify again, is that I am supportive of there being a register of interests. I think that is what the public wants to see, I would say, if people have thought about it. What that looks like in its absolute finality, I might be asked for my opinion, but, you know, as we sit here today, I'm not sure that I can go into all the ins and outs of exactly what that would look like.
I appreciate that, Ms.
Okay.
Thompson. Thank you very much for your evidence.
Angus.
Thanks, Convener. Good morning, Ms. Thompson.
Morning.
Just following on from that point, there's an argument that the information on a register could be abused by the media, hostile individuals, or indeed dissatisfied litigants. Do you have any view on that argument?
It is an inevitability in my personal experience that when you put information out into the public, that different interests might cross over. I have had personal experience of that really just very recently, so there was an issue that I had to deal with in relation to what looked like some sort of cross-purposing of some different roles that I hold, but that was just a misunderstanding on the part of the person who was seeking to investigate a bit further, and one has to spend a bit of time, in my experience, unscrambling some of that, but I'm not sure that I would necessarily say that that's a reason for not doing it.
Okay, thank you. I should have said litigant.
These things need to be managed. Of course, they need to be managed, as I've indicated in my response in January. I mean, you know, somebody would need to hold the register. It would need to be managed. Of course, there's an on-cost in relation to all of that. But I think, as I'm understanding the nature of the petition, it's about seeking some clarity for those people who are going to court in terms of interests that judges may hold that are not known.
Okay, thank you. While I've got the floor, Convener, can I go back to an earlier point that was raised? You indicated that you agree with your predecessor's view that the powers of the JCR to review the complaints process are actually quite limited. If that is the case, and you agree with your predecessor, do you have any plans to review the complaints process?
It's not for me to review.
No.
I have said to Scottish Government that I think that we're 4 years into the role, and the role is now held by the second person in the role. And so the time, as far as I'm concerned, sitting here, it probably would be time to start thinking about the possibility of reviewing whether or not what was originally envisaged under the primary legislation, which was passed in 2008, is what is still required. So I'm supportive, as always, as an old civil servant, in terms of, you know, we have a piece of legislation, there's a policy, there's a concept, we have something that the Parliament agrees to, it's in force for a while, and then at some point or another, and a three or 4 year period seems to me not unreasonable, to go back and have a look and see whether or not it's still meeting its requirements. And I would say that, I mean, I'm sitting in the role, but, you know, a review might say, maybe we don't need one. Maybe we don't need a JCR. I'm not saying that. I'm just saying that there's lots of different ways to look at this. And I wouldn't be putting my hand up and saying, oh, we absolutely have to have. What I'm interested in is this, bluntly, is this value for money. You know, is the public getting value for money? At the moment, I think that generally speaking, well, I'm hopeful that I'm giving value for money. I'm getting more efficient at doing the reviews and so on and so forth, and the speed will come and so on and so forth. However, it is a question as to, it is a very narrow rule, only looking at whether the rules have been followed. That's it. Not looking at anything else over and above that, the whys, the wherefores, the how could that possibly, is that reasonable? None of that. I may have thoughts, but that's not my role. So, a review, yes. Not for me to do, however. Input, yes, but that's for someone else to carry out, should they decide that there's scope and appetite and it fits in with all the other work that needs to be done.
But, well, presumably it will be a priority that you will raise with the new Lord President once he or she is appointed.
I will, as I have already raised it with Scottish Government, my contacts in Scottish Government, including Mr Wheelhouse, who I met in January.
Okay, thank you.
Zola?
Good morning.
Good morning.
I just wondered, you made a comment about it's taking you perhaps 4 to 5 months to deal with individual cases, and you yourself have suggested that perhaps that's a little long. And so it's without saying that I would then ask, what do you think would be a reasonable time, and do you think you'll be able to meet that in the near future in terms of reducing the time that it's taking you just now? Well, I know you're not in for very long, so I appreciate that. Yeah. that I'm asking you to set yourself almost a challenge. And,
okay. Well, I've already done that, and as you may be aware, the contract with the JCR and Scottish Government is for up to 3 days a month, and I have been working more days than that by agreement with Scottish Government. So, for example, from the middle of December, I've been working 4 days a month, and because the backlog just refuses to go down, largely because of input, you know, and so on. And of course, it's demand-led, so a demand-led service on a restricted number of days is always going to be a bit of a headache for the person who's delivering the service and for the people who are waiting. So I did put a proposal to Scottish Government in May, I think it was, and they've come back and agreed that, and I'm doing 6 days this month, next month, and August. Now, will I clear the backlog? No. I will get through it. I can, with 2 days, 2 days extra over and above the 4, so effectively twice as many as the contract says. I should be able to push through enough cases to get to, I would like to say exactly how many, and it depends on the complexity, of course, because some are very straightforward, and you can see some require me to give a bit more thought, maybe to seek some clarification and so on and so forth. And then everybody is entitled that I spend a bit of time thinking about what I'm going to say. I mean, as the second in the role, I've been able to pick up the processes that Moy put in place. Do they need reviewing? Yes, they probably do, but I don't have time. So my hope is that by the end of August, I will have substantially moved through the backlog. I don't think it's appropriate I have a background in public service, specifically in frontline service. So I think it's a long time for people to wait 4 to 5 months. Although, of course, I write to them, I keep them up to date about, how much longer they can expect to wait and things like that. So I'm not sure. Today, I don't think I want to put a figure on it, other than to say that I'm moving through the cases more quickly now. I think they take about a day and a half maybe, to do a case, which is reasonably complex. I could do 2 cases in one day if it was pretty straightforward and there wasn't much paperwork to look at. Do you see what I mean? So I would like to get to a position where there was no backlog and I was dealing with things as they came in, but frankly I think that's unlikely. In addition to the 22 cases that have come into me since the 1st of September, I've also had 7 inquiries, and I've put a telephone number on the website, which there wasn't one before, so I get telephone inquiries as well. And then of course there's events like today and other things and other meetings and things like which I do in days when I'm not working, if you follow me. Well, it has to be realistic about these things.
If you allow me to follow up. I genuinely appreciate your response. It's very honest and very balanced. However, I don't think it actually helps you, what you're telling me. It suggests that there's more pressure on what you're trying to achieve, at the risk of, I'm not suggesting for a moment that your work would be diluted, but it certainly puts a lot of pressure on you to try and get through the cases for the times that you're doing it. And I would perhaps suggest that you may want to explore the possibility of either getting yourself more help or even more days to try and achieve the good goals that perhaps you yourself would like to see set. So I wish you good luck with that.
Well, thank you. And if there was to be a review, I think that would need to be part and parcel of the review, bearing in mind that I remain in the position of I do everything. Yeah. So things like the housekeeping and the website and that sort of thing, which really do need attention, are things that I dream about at night. They're not keeping me awake, but yes. You know what I mean.
Yes, I do. Yeah. Thank you. Thank you very much.
Ms Thompson, in an earlier response to Angus MacDonald, you said that you didn't think it was your responsibility to do a review of the rules. Do you believe then that the current rules are fit for purpose?
We're talking here about my role as opposed to the rules, because the rules belong to the Judicial Office for Scotland.
Do you believe then that the complaints process run by the Judicial Office of Scotland is fit for purpose?
It is fit for the purpose that is currently in place. I might expand on that by saying that I'm in absolutely no doubt that the process that is in place at the Judicial Office for Scotland has improved, did improve during the time that my predecessor was in post. And I think when she left, she felt that she hadn't added the sort of value that she would have wished to. But picking up where she left off and having had a number of conversations, meetings with the Judicial Office for Scotland, I'm satisfied that the process has grown organically and improved, and the way in which they deal with the throughput and so forth, and the letters that they write and so on, it has improved. So, as we would hope, complaints process equals service improvements at the entity that is, the complaints are looking at. The new rules came into effect on the 1st of April 2015. I think they're an improvement, a bit of sequencing, rules following, streamlining, a bit more explanation to people who are trying to find their way through the systems. The guidance leaflet was improved. So that's one question. The other question is, do I think that the Judicial Complaints Reviewer, I think that, I'm interpreting your question now, is the JCR fit for purpose? As it's currently constituted, it does what the regulation, what is required of the JCR. Could it do more? Well, yes, it could, but that would require somebody to say we need more, because it is very one-dimensional, as I've said.
Okay, then, as you rightly said, the new complaints rules were published on April 1st.
Yes.
How far then do you think they went to address the concerns highlighted by your predecessor?
Well, in small measure, I think. Moy had undertaken, I don't know whether you're aware, so forgive me if I'm telling you something you know, but she had undertaken a mini consultation amongst the people that she had, who'd asked for a review, and so that she sent that out. So when there was a consultation done by the Judicial Office for Scotland, Moy also did her own consultation, and then she parcelled all of that up and sent that to the Judicial Office. And you may have seen that the Judicial Office, in tandem with publishing the rules, also published the consultation response, which set out, the things they had taken on, the things they hadn't. So I suppose in answer to your question is that in some part, I think they did go a little way to responding to some of the concerns that she had expressed about the rules and the way in which the rules work. Some of that was around the understanding of the person who is coming up against the rules, because, sometimes it's difficult for people who are inexperienced to properly understand what the different rules mean. So I was also asked for my view, because there was quite a bit of time went by, and offered some, what I hoped were helpful suggestions. But the Judicial Office, well, not but and, the Judicial Office took a view, obviously, in the totality of the responses they got, and made a determination that the Lord President was able to agree. Doesn't really answer your question, I know. So, in part, I don't know whether you've seen, I don't know if the committee might be interested in having a look at the response document that was issued by the Judicial Office for Scotland. If you haven't seen it, it is quite helpful in understanding the changes that were made to the rules.
Okay. Any further quick? John?
Ms Thompson, to clarify, could you remind us how many responses there were made to the review that was carried out?
To
the Judicial Office's review held under the Lord President. I'm
not sure that I know. I have a piece of paper with me which I can look up and leave, but...
what we have in front of us is information to say there was 5 responses.
Oh, yes. Well, it was a very small handful. Yes. It wasn't like masses of numbers. Yeah. And I know that you can, construe your own view on that. Well, although I should just clarify that I did go back to the Judicial Office and ask whether or not they'd taken into account the responses that my predecessor had in terms of that, but I seem to remember being told that they had not, so they'd taken a response from...
That was going to be my follow-up question, Ms Thompson, whether your predecessor's responses had been included in those 5.
As one.
As one?
Yes.
Yeah.
I believe so. Yes.
Is there any further questions? Could the committee now decide what action it wishes to take on its petitions? Views to the members?
You'd be writing to the incoming Lord President, asking him what his view is, given the clear expressions, not just now of one Judicial Complaints Reviewer, but 2, and see whether the new Lord President, whoever he or she may be otherwise minded. I think we're probably incumbent to wait and see what they say before we consider it further, but asking you, Lord President, equally given the view of from Ms Thompson, it does seem to me that it might be worthwhile asking the Scottish Government whether this is an opportune moment to review the office of JCR, given her comments, and that would be a matter dealt with by them, not by the Lord President. But it seems to be that there's a possibility of perhaps a new regime at the judiciary with the new Lord President, and equally, after 4 years and into the second Judicial Complaints Reviewer, is the job what we want it, or should it be reviewed? It doesn't have to be a lengthy consideration or review, but is it doing what we want? And if the role is to expand, perhaps dependent upon the Lord President, how much further should it go if there's a judicial, register?
Jackson.
Thank you, Convener. I return to the fact that when this petition first came before us, I was actually deeply sceptical of it and became more persuaded that it may have merit in response to the reaction we had to it and to the inquiries that we made. I support what Mr McCaskill said. I wonder whether the attitude of the incoming President to subsequent to giving us his view, offering himself to the committee to allow us to examine that, whether that will be the same as his predecessor, but I think it might be worth inquiring. But I think first we need to see what he has to say. But the principal reason I think that his predecessor felt that it wouldn't be appropriate was that he didn't see how in office it would be incumbent upon him to do that. And I wonder now that he's not in office whether he would be willing to come before the committee to allow us to understand further the perspective that he took. I was always open to persuasion on this issue. It's been the lack of an argument which seems to sustain itself in a reasonable fashion that has led me to remain to be sympathetic to the aims of the petition. The clerk to the committee has advised me that it's in fact not competent for this committee to initiate a bill of our own. Of course, it's open to any member of the Parliament to do that, and to do that in this session of Parliament or in the next. But there does seem, as I think Ms Thompson has said, and which is evidence outside of here, a clear public interest in this issue, which has found expression. And in the absence of a more substantive argument than the impression that it's not something we want, in inverted commas, I really think this committee should be reluctant to allow the petition to run into the sand, but should do all we can to sustain it and to pursue its objectives for as long as we feel able to do so. So I would support the suggestions made, but add just the additional thoughts as well.
John Molson.
Yeah, thank you. Can I suggest that if we're writing to the Scottish Government to seek their views, could we get clarification on the further evidence that's been provided by the petitioner regarding the legal advice that the Scottish Government sought? I know that there is and we have copies of the correspondence the petitioner received saying that the Scottish Government feel at the present moment it is not advisable to release the legal advice. But could I ask if we seek clarification about when that legal advice was sought and why they felt it necessary to seek that advice? Because I think there is an issue here in terms of, while we might not get the legal advice as it's such, they have admitted in the correspondence that legal advice was sought, and I would like clarification on when they did seek that and the reasons why they sought that legal advice.
Okay. Anybody else? Do members therefore agree on the action that's been promoted? Agreed. Thank you. Can I thank Ms Thompson, sorry, before you leave, can I thank you for attending, and we'll now suspend for a couple of minutes for a changeover.